One of the most amazing developments in respect of this sequence of events was the statement by the President yesterday that the way out of this situation is for the Speaker of Parliament within 7 days to discuss this issue with His Lordship, the Chief Justice. I have never heard of a more preposterous suggestion. This is an ongoing case. This litigation is not over. It has not reached its conclusion. What 3 judges of the Supreme Court have pronounced up to now is an interim order giving leave to proceed and allowing interim relief. It is not the final order. The case has been adjourned. It is going to be taken up again in November, after the presidential election. So it is a continuing case before their lordships of the Supreme Court. If now the Speaker were to take the extraordinary and totally indefensible, totally unwarranted step of approaching the Chief Justice in order to discuss with the Chief Justice an ongoing case before the Supreme Court, there is absolutely no doubt that the Speaker is in contempt of court. If the Speaker wishes to please the President and take this step, then quite definitely, without any doubt whatsoever, he is exposing himself to liability for contempt of court. He is doing something unthinkable. He is going to talk to the Chief Justice about an ongoing case. Now, we must also remember that the Speaker has no immunity whatsoever under the Constitution and the laws of this country. He is no different from any other citizen. If he commits contempt of court, he must bear the full severity of the consequences. The full severity of the consequences. So there is no solution. If that were to be done, we will take appropriate action in that regard, in order to implement the laws of this country. In that case, what should be done? What should be done is obvious. The President must act in accordance with the provisions of the Constitution. He must now appoint an acting Inspector General of Police. He has the full authority to do that. An acting IGP can function for 14 days. After that, if the President wishes to confirm that appointment or to send up another name, then the responsibility is taken by the Constitutional Council. The Constitutional Council. The President's proposal is only a recommendation. It is not a final decision. In order for that to be implemented, the approval, the concurrence of the Constitutional Council is a necessary requirement. It is mandatory. It is compulsory. Without that condition being fulfilled, the President cannot make that appointment. So if he sends up a name and the Constitutional Council endorses that name, gives its agreement and approval, then the responsibility is taken by the Constitutional Council. It is not solely and exclusively the responsibility of the President. Consequently, this talk of danger of an election petition is absolute nonsense. Total and complete nonsense. There is not a tinge of validity about that suggestion. There is no prospect or possibility whatsoever of an election petition. How can there be an election petition? The Constitutional Council has taken responsibility. It is being done under the full cover and authority of the Constitutional Council. Why is the President resorting to this absolutely ridiculous argument? He has meticulously prepared the ground for this preposterous suggestion to be made. Why? Because within the first few hours, a deposit was made on his behalf in the election commission. The first few hours, President was the first person to make his deposit. 17 more days to go, 17 days to go, but he rushes in. And in the greatest hurry, the deposit is made. Why? For no other reason than to prepare the ground for this laughable suggestion regarding the risk of an election petition. It is an elaborate pretext without an ounce of good faith, entirely to serve an ulterior purpose, to create as many problems as possible with regard to the presidential election and to serve his own personal objectives, to further his own ambitions with regard to this presidential election. So, the president must conform to the law. It is part of the duties of his office. He must facilitate the conduct of major elections in this country, and there is no more important election than the presidential election. But I want to say this, whether the president cooperates or not, if he perseveres in this obstinate, arrogant course of conduct for the purpose of advancing his own candidacy at the presidential election, the law is by no means impotent. The constitution and the law of this country is strong enough to protect the rights of our people. Irrespective of the attitude of the president, the Elections Commission has the fullest authority to issue the necessary directions to the police in order to enable the conduct of this election without any delay on the appointed date, the 21st of September, in accordance with the Constitution and the law. Articles 104G and 104GG expressly confer upon the Elections Commission the fullest authority to issue appropriate directions to the police to enable this election to be held on schedule. Therefore, the people of this country need entertain no doubt or fear that the obstructionist behavior of the president will result in a situation where the election cannot be. Of course, the election has failed. If the president goes for one more day beyond that, it is an illegal government. He is a usurper. He is no longer the lawful president of the country. That is a calamity beyond imagination. It is not going to happen in a country with such a strongly established democratic tradition. So whatever the president may or may not do, whether he complies with the Constitution or not, whether he complies with an order of the Supreme Court or not, whatever tactics he may resort to, this election will take place on the 21st of September, and the Elections Commission is fully empowered to ensure that that happens.